Next on Investigative Report. Ending cash bail. The constitutionality of selling freedoms. Each day in an American city, someone is arrested for an offense for which the judge offers bail over pretrial confinement. New York State and other municipalities have done away with their cash bail systems, which propelled the bail lobbying industry to go into overdrive. Because of this new trend, many novice and legal scholars alike debate the merits of erasing these crime deterrent penalties, while others point out that the current system has yet to prevent or stop crime. For now, judges continue to gavel their pretrial confinement sentencing, while bail bondsmen reap the profit from a $2 billion a year trafficking industry. An industry that pawns human souls from gaudily painted strip mall locations, which allows some to be set free and others to be locked away based upon what they can pay. In this investigative report, we explore the constitutional merits of the modern bail system. And now, ending cash bail, the constitutionality of selling freedoms. In the People's Republic of China, in certain circumstances, one could get 3 years for simple pickpocketing, or longer for stealing a backpack. But this could never happen in America, right? Wrong. Hard to believe, but a country once founded on literal freedoms based upon citizenship would morph into little more than a parceled out pardon until you're arrested. Colonists fought and formed a new nation out of despising the fact that British soldiers of the monarchy were given carte blanche to search people's homes, papers, and belongings at will. Oppressive governance like this would lead to the Declaration of Independence, a Revolutionary War, and finally a constitution guaranteeing the poor citizens equal rights, or so we thought. In 1897, the Supreme Court struck down a Louisiana statute for violating an individual's liberty of contract. But our modern Supreme Court appears as if it seeks to some way abridge the freedoms that the founders intended for us to enjoy. A court that allows compulsory stopping of citizens for minor infractions that lead to arrests reflects little more than the acts of British soldiers towards the colonists. Some see these acts as a violation of the Constitution through the Fourth Amendment, which protects people from unreasonable searches and seizures by the government. Unequal acts like these are tested, such as when the government had a draft for wars in which men of lesser means were drafted far more than males of wealthy individuals during the Vietnam War. By war's end, there will be so many protests and blowback to the government's doctrine that this style of conscription will be replaced by the all-volunteer force, a force that would allow females to serve but not to be drafted like their male counterparts. Dr. King's quotation from the Declaration of Independence in his I Have a Dream speech was a direct challenge to the government's treatment of its poor citizens as opposed to imaginary qualities professed in that sacred document. What Dr. King was aware of in America is whenever there is a direct challenge to the Constitution, it will never actually be based on color, religion, or creed. The driver of all indifferences initiated from a governmental level, be it bail or otherwise, is usually based upon whichever privileged group it caters to in a particular era. All constitutional battles that have been won have been based on a lesser group being treated unfairly to a privileged group. Just as the cash bail system marks the privilege of inequality of income, a system where a person who does not have enough cash at the moment is imprisoned before trial because they cannot afford to barter for the freedoms that they were already accorded to in the Constitution. By jurisprudence concerning a presumption of innocence in which any defendant in a criminal trial is assumed to be innocent until they have been proven guilty. As such, a prosecutor is required to prove beyond a reasonable doubt that the person committed the crime if that person is to be convicted. And finally, The Speedy Trial Clause of the Sixth Amendment to the United States Constitution provides in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. Recent challenges to the bail system came up during the last presidential election, as many Democrats ran on the promise to overhaul or get rid of the cash bail system as we know it today. Senator Bernie Sanders addressed cash bail inequalities and placed the entire scheme in a light that anyone could understand.
Everybody knows the United States has a broken criminal justice system. We have over 2 million people in jail, more than any other nation on earth, and they are disproportionately African American, Latino, and Native American. We spend $80 billion a year keeping people behind bars, money which could and should be used for education, job creation, and affordable housing. On any given day in the United States, there are over 700,000 people in county or city jails. In 2016, more than 65% of that jail population was unconvicted, meaning that more than 400,000 people are in jail today who have not been convicted of a crime. In other words, we have criminalized poverty, and that is not acceptable. Pre-trial detention should not be based on how much money a person has, or what kind of mood the judge is on a given day, or even what judge the case happens to come before. In a country where we pride ourselves on the principle of innocent until proven guilty, we should not be keeping hundreds of thousands of people locked up before they have actually been convicted of a crime. In 2016, the average length of stay in jail for the entire jail population was 25 days. The sad truth is that people who can't afford bail and who spend 3 or 4 weeks in jail awaiting trial are likely to lose their jobs, their income, they won't be able to pay their rent, and may find themselves homeless. They may even lose custody of their children, all because they don't have enough money to buy their way out of jail. It is quite simply a travesty that in the year 2018, we continue to have debtors' prisons in the United States of America. We can and must find a better way. And there are communities we can learn from who have already implemented alternative systems. More than 2 decades ago, Washington, D.C. created a system where very few defendants are required to post cash bail to be released. In fact, about 90% of defendants are released on promises and conditions other than cash, and 90% of those released do not reoffend before trial. No one is locked up because of inability to pay. Today, I am introducing legislation in the Senate called the No Money Bail Act to abolish the use of cash bail in federal courts and to help state and local governments implement alternatives to this broken and destructive system. 4 words are engraved on the front of the United States Supreme Court: equal justice under law. Needless to say, we are very far from that ideal today. I hope this legislation will bring us a step closer.
Senator Sanders' words painted eloquently the most heinous example of cash bail system abuse, which brought about the tragic imprisonment of a young boy turned Bronx teen in New York City. His name? Kalief Browder. Kalief Browder was a foster care child adopted from a crack-addicted mother into a loving home with promise for the future until one fate-filled night. On May 15, 2010, police stopped and apprehended 15-year-old Kalief and his childhood friend on Arthur Avenue near 8th 186th Street in Belmont section in the Bronx. Kalief was going home from a party, talking with his friend when he noticed police lights and highlights. He thought the police were carrying out a routine stop and frisk, a police procedure that he had undergone on a number of occasions. Police officers responded to a 911 call placed by Roberto Batista about the theft of his brother's backpack, which he said contained a camera, $700, a credit card, and an iPod Touch. Batista told dispatchers 2 male black guys took my brother's book bag. Kalief, who police had already handcuffed, told the attending police officers, "I didn't rob anyone. You can check my pockets." The police searched Kalief's pockets, but they did not find the backpack. Batista, the accuser, who was sitting in the back of a police car, identified Khalif and his friend as the thieves. Mr. Bautista would go on and change his story about the said robbery many times before, during, and after Khalif was arrested. Now, initially, Bautista implied that the robbery occurred the night of the 911 call, but upon questioning by officers at the scene, he stated that the robbery had occurred 2 weeks prior. At the scene, Bautista also implied after questioning that someone had merely tried to rob him and may not have succeeded. Furthermore, on the initial police report filed after the arrest, Bautista indicated that the robbery had occurred on about May the 2nd. But Bautista later told a detective that it happened on May 8th. Now, this type of victim confession normally invalidates their statement, but not in this case, and things were about to get much worse. 17 hours after the arrest, Khalif was interrogated by a police officer and a prosecutor. The following day, Khalif was charged with robbery, grand larceny, and assault. Because he was on probation, Khalif was not to be released. Now, apparently, a year before, in an attempt to hang around with the wrong crowd, Khalif took a bakery truck on a joyride before he was arrested by police officers. Now, although he was innocent of the book bag heist, his prior conviction proved problematic in this case. At his arraignment, Khalif was charged with second-degree robbery and bail was set at $3,000. Khalif's family could not raise this amount and borrowed money from a neighbor. Khalif was taken to a jail at Rikers Island to await trial and resolution of his pending probation violation. Khalif was jailed at the Robert N. Daron Center on Rikers Island. The Robert N. Daron Center had a deep-seated culture of violence in which inmates suffered broken jaws, broken orbital bones, broken noses, long bone fractures, and lacerations requiring stitches. Now, unfortunately for Khalif, he would be imprisoned there for over 1,000 days, of which 800 would be in solitary confinement. And all of this for a backpack incident in which he never was convicted. On another occasion, Khalif was assaulted by a guard as he was escorted to take his shower. Here is that actual video. On October 20th, 2010, a gang member spat in Khalif's face. Later in the day, Khalif punched a gang leader and was then jumped by 15 gang members for doing so. Here is that actual video. Altogether, Khalif spent nearly 2 years in solitary confinement in this nightmarish of a place. Khalif later said that while in solitary confinement, corrections officers beat him when he was showering. He said a verbal confrontation with the guard would escalate into a physical altercation. During his time in solitary confinement, Khalif was allowed to participate in activities such as reading. He also studied for the General Educational Development, or GED, in order to complete his high school diploma. Attorney Brendan O'Meara was appointed as Khalif's public defender. Khalif always maintained his innocence. Although the Assistant District Attorney Peter Kennedy called Khalif's situation a relatively straightforward case, his trial was delayed by a backlog of work at the Bronx County District Attorney's office. In July 2010, 74 days after his arrest, Khalif was brought before a judge at the Bronx County Hall of Justice. The grand jury indicted him on a charge of second-degree robbery. A second charge of punching and pushing Batista was heard. Khalif pleaded not guilty, and a higher amount of bail was set, although he would not be released. While incarcerated in 2010, Khalif made his first attempt to take his own life. He tried a second time on February 8, 2012. At that time, trying to hang himself using strips of sheet tied to a ceiling light in his cell. Khalif later said the CO guards goaded him to go ahead and just do it. On another occasion, after an appearance before a judge, Khalif made a sharp implement from the bucket in his cell and started to slit his wrist before an officer intervened. Khalif Browder would go before the judge 34 times while incarcerated at Rikers because of massive delays in the system in order just to win his freedom. A freedom that would not come for 3 years after his arrest without as much as a trial or an apology for incarceration. After his release, Khalif and his brother Akeem sought legal representation for his false imprisonment. A family member found the Brooklyn civil rights attorney Paul V. Prestia. In November 2013, Khalif would file a lawsuit against the New York City Police Department, the Bronx District Attorney, and the Department of Corrections. Prestia claimed that there had been a malicious prosecution, and the court had been misled about the prosecution's readiness for trial. Prestia also put to the court that the prosecution knew that they would have no witness as Batista, his accuser, returned to Mexico long before Khalif was ever released. The city of New York would ultimately deny these allegations. After his release, Khalif continued to have symptoms of depression. He said, "People tell me because I have this case against the city, I'm all right. But I'm not all right. I'm messed up. I know that I might see some money from this case, but that's not going to help me mentally. I'm mentally scared right now. That's how I feel. There are certain things that changed about me, and they might not change back. Before I went to jail, I didn't know about a lot of stuff. And now that I'm aware, I'm paranoid. I feel I was robbed of my happiness." In November 2013, Khalif made yet another attempt to harm himself and was admitted to the psychiatric ward at St. Barnabas Hospital, the first of 3 admissions to the ward. On June 6, 2015, at 12:15 p.m., Khalif Browder hanged himself from an air-conditioned unit outside a window at his mother's home here at 2124 Prospect Avenue in the Bronx. His mother, the only person at home at the time, heard a thump upstairs. Then she ran up but could see no one. She then ran outside to check where she had ultimately saw Khalif hanging by a cord. On June 16, 2015, Khalif Browder was laid to rest, a young man no longer troubled by the voices that bothered him on Rikers. The boy, now a man never convicted of a backpack robbery, whose family didn't have enough bail. The child turned man who was let down by a system charged to look out for his well-being. 1 week before his funeral, mourners mounted a 3-hour vigil near Manhattan Detention Center and chanted justice for Khalif. A concurrent vigil was held on Rikers Island. On June 27, 2015, an event on Rikers Island was organized through Facebook under the banner March to Shut Down Rikers, Justice for Khalif. No decriminalization, and the hashtag Resist Rikers and Shut Down Rikers. On October 14, 2016, Khalif Browder's mother, Benita Browder, died of complications of a heart attack. Khalif's attorney, Prestia, said, "In my opinion, she literally died of a broken heart because the stress from the crusade, coupled with the strain of pending lawsuit against the city and the pain from the death, was too much for her to bear." Until we can make a bail system that represents all, or eliminate it entirely, be very careful of the lights in your rearview mirror. If Khalif could spend 3 years in jail for a backpack he never stole, what could happen to you in the land of the free for cost? All of us, and I do mean all of us, are one step away from losing a job, leaving us behind bars until our delayed trial date. For Investigative Report, this is Charles Rivers. Thank you for watching.